just a quick announcement before we get started. I just wanted to follow up on from the last panel. We had gotten a question about resources related to domestic violence. I was just going to add a couple of additional sources to the list that came in for me. One is safehousealliance.org. Another is violencefreecolorado.org. The last thing I'll do is just give that hotline number again, which is a nationwide hotline, because I know we have people maybe from all over the country on this webinar. That number is 800-799-SAFE. 800-799-SAFE, which is also 799-7233. Okay, so just wanted to make sure that people had those resources. So let me start off by saying thank you. I'm excited to see the second panel. And the panel we have today is Barriers to Political Representation. And our moderator, who will be taking it from here, is Jane Waterman. So Jane, please take it away. Thank you.
Hi, everyone. Thank you, and welcome to our second panel, all about barriers to political representation. We have 4 amazing panelists for you today, and I'm really excited to hear from them. Just a quick roadmap. I'm going to introduce all the panelists. They will give their talks, and then we'll have time for a Q&A at the end. So if you are on the Zoom webinar and you have a question, go ahead and put that in the Q&A, and we'll get that answered for you. Our first panelist today is Professor Strolovitch. Professor Strolovitch is currently a professor at Princeton, where she holds appointments in gender and sexuality studies, African American studies, in the Department of Politics. Next year, she'll be joining the faculty at Yale as a professor of women's, gender, and sexuality studies, American studies, and political science. Her research focuses on American politics, political representation, and the intersecting politics of race, class, gender, and sexuality. She has an award-winning book, Affirmative Advocacy, Race, Class, and Gender in Interest Group Politics, as well as publications across numerous journals. Her next book, When Bad Things Happen to Privileged People, Race, Gender, and the Political Construction of Crisis and Non-Crisis, is forthcoming from the University of Chicago Press. Our second panelist is Professor Bertrall Ross. Professor Ross is the Chancellor's Professor of Law at UC Berkeley. His research concerns democratic responsiveness and accountability, as well as the inclusion of marginalized communities in the political process. Professor Ross's past scholarship in election law, constitutional law, and statutory interpretation has been published in the Columbia Law Review, NYU Law Review, and the University of Chicago Law Review, among lots of others. He has 2 forthcoming book projects, one on gerrymandering and the other on the use of voter data as a tool for disenfranchisement. He earned his JD from Yale and master's degrees from both the London School of Economics and Princeton University's Woodrow Wilson School of Public and International Affairs. Our third panelist is Professor Atiba Ellis. He is a professor at Marquette University School of Law. His research focuses on how varying conceptions of the right to vote may discourage and exclude voters from marginalized communities. His writing includes discussions of the economic entry barriers inherent in voter ID laws, the theoretical scope of Citizens United, the race or part dilemma in voting rights law, and related topics. Currently, his research centers on how ideological conceptions of who a wrongful voter is animates voter suppression efforts. Professor Ellis is a frequent speaker at conferences, universities, law schools, and community events around voting rights, diversity issues, and related matters in politics and civil rights law. Our last panelist is Professor Ming Chen, who was my library professor. She's a professor here at CU Law, where she is the faculty director of Immigration and Citizenship Law program. She also holds faculty affiliations in political science and ethnic studies, bringing an interdisciplinary perspective to the study of immigration, civil rights, and the administrative state. At the law school, she teaches a variety of classes focusing on law and social science, including immigration law, citizenship law, admin law, legislation and regulation, law and social change, as well as law and politics, race in America. Her first solo-authored book, Pursuing Citizenship in the Enforcement Area, will be published by Stanford University Press in May. And so without further ado, I'm going to hand it over to Professor Strolovitch for her presentation.
Sorry, am I successfully unmuted now? Yes, okay, thank you. Thank you. So like everyone so far today, I want to start by recognizing the sort of strangeness, scariness, and overwhelmingness of this moment, but also by thanking Professor Stiepel for her incredibly moving and generative keynote, Suzette and Ming for inviting me, and also Melissa and the other organizers for their hard work and what I've decided to call creative perseverance to make this event actually happen. I think we're all sort of finding our way through all of this. And I also want to give two quick caveats before I begin, as I think came through in the introduction, and thank you for that, Jane. Although feminist and critical race legal theory are central to my work and to what I'm going to talk about, I'm a political scientist, not a legal scholar, so this sort of comes from a slightly different register in some ways than many of the other talks today and on this panel. And second, though some of my research has addressed barriers to the kinds of formal political participation and representation for marginalized groups that the 19th Amendment and voting rights more generally were intended to secure and protect, most of my work has actually taken those kinds of barriers as a point of departure for looking instead at what I think of as extra-institutional forms of politics, exploring whether, to what extent and in what ways more informal representatives like advocacy groups and social movements can help to compensate for the limitations of and barriers to formal enfranchisement and representation, particularly when it comes to intersectionally marginalized subgroups of broader marginalized groups. So in other words, I've tried to address questions about intersectional marginalization and the role of social and economic justice advocacy groups and movements as what I call compensatory representatives for marginalized groups, by which I mean that they give members of marginalized groups with common interests but inadequate formal political representation an avenue through which to have their voices heard in national politics and to try to influence elected officials in ways that might not be possible through more formal or institutionalized channels. Now, while advocacy organizations and social movements have often been the strongest and sometimes even the only voice for the interests of groups like women, people of color, low-income people, LGBT people, groups that have long been, and as we've been talking about already today, remain underrepresented in legislative bodies, underserved by the two-party first-past-the-post and territorially based elections. Even though they were sometimes the only voice for these groups, they're nonetheless historically at a severe disadvantage, particularly through the 20th century, generally outnumbered, out-resourced by interest groups that spoke for more powerful and often explicitly anti-egalitarian interests. Now some of that changed. Oh, and I have to start my screen share. One sec. See if I can do that. Okay. Did that work? Can people see my slides? Yes, okay, great. So some of that changed when the movements of what historians often call the movements of the long 1960s mobilized historically marginalized and excluded groups, led to this explosion that we see in this graph in the number of organizations speaking on behalf of these groups. But even with the proliferation of these kinds of advocacy organizations, and even though it's a striking feature of contemporary American politics, and even though organizations that represent women, people of color, LGBT people, low-income people have helped to usher in significant legal and policy gains, many scholars and political actors also allege that they focus on the needs of more advantaged members of marginalized constituencies on whose behalf they speak. And we've been talking a little bit about that today. So this is where I've tried to enter the conversation by examining how these groups that claim to represent groups like women, people of color, LGBT people, low-income people, how do they advocate on behalf of intersectionally marginalized subgroups of their broader constituencies? And so I ask how active and in what ways they are when it comes to policy issues that affect intersectionally marginalized subgroups of their constituencies. And to try to get a handle on these questions empirically, I've done a series of surveys and face-to-face interviews with officers at organizations like this. I'm going to focus mainly on the findings from the first survey that I did in 2001. I'll say a little bit about a second study from about 7 years later in 2007, and then talk very briefly and speculatively about one that's currently in progress. So in the first study, I asked respondents a series of questions about the levels and nature and targets of their advocacy activities on 4 domestic policy issues that I assigned to different types of organizations based on a 4-part typology that I created to try to operationalize key aspects of intersectional theories about power and marginalization, and to test them against competing claims, like the argument that organizations are basically trying to prioritize issues that they believe have a broad impact, or that they're focusing on social issues at the expense of economic ones, or vice versa. And as you can see in the typology, the 4 policy types are majority issues, which affect an organization's members or constituents relatively equally. So as you can see in this figure, I asked respondents from women's organizations about their advocacy efforts on violence against women, as all women are at least theoretically equally likely to be affected by violence, even if not every woman is in her lifetime. The second type is disadvantaged subgroup issues, which affect a subgroup of an organization's constituents that's intersectionally marginalized, so it's disadvantaged economically, socially, or politically compared to the broader constituency. So I asked these same respondents from women's organizations about welfare reform as a disadvantaged subgroup issue, which intersects gender and class and often race, affecting low-income women, intersectionally disadvantaged subgroup of all women. Third, there are advantaged subgroup issues, which also affect a subgroup of an organization's constituents, but a relatively advantaged or privileged subgroup, and it's important compared to the broader constituency, so not compared to the general population, relative to which they're still nonetheless disadvantaged. So continuing the example for feminist or women's organizations, I asked them about affirmative action in higher education, which affects primarily college-educated or college-bound women, which is a relatively privileged subgroup of all women. And then finally, at the bottom, you can see universal issues, which again, at least in theory, affect the population as a whole, regardless of race, gender, sexual orientation, disability, class, or any other identity or access of marginalization. And just to give you a sense of the other issues I asked about here, they are sort of array for all other kinds of organizations. I don't want to spend, or I can't spend too much time going through the specific findings in detail. Happy to talk later about anything. But for now, I want to point out 3 of what I think of as the most germane punchlines, generally, but certainly for the topics of this conference. So the first is that advocacy groups are, I think I show, a pretty good, important source of compensatory representation for marginalized groups. That is, they claim to be committed to a broad range of constituencies. They're also active on a wide array of policy issues and areas. So they are fulfilling in some ways this important compensatory role. But what this figure is showing is the proportion of organizations active on each type of issue. And what it makes clear is that even though they're interested in and trying to address a broad array of issues and constituencies, they're much less active when it comes to issues affecting intersectionally disadvantaged subgroup issues than they are when it comes to majority or advantaged subgroup issues. And without getting too much into the weeds, the difference between what looks kind of here like staircases, so going down in this particular figure, and the more sort of curvilinear shapes in this one, and especially if you look at the dotted bar for advantaged subgroup issues on the left side of the figure, it shoots right up. What this is showing is that the disparity persists and actually becomes even more stark if we control for a range of other factors, including, in this case, breadth of impact. And then looking at these predicted probabilities of activity that take into account also the contingent effects of impact as they vary by policy type, shows that organizations are actually more active on advantaged subgroup issues that their executive directors or officers judge have a low level of impact than on disadvantaged subgroup issues that respondents judged affected almost all of their constituents. So in other words, going back to this idea of trying to think about this relative to competing explanations, these organizations aren't prioritizing issues that benefit the greatest number of their constituents, but instead issues that benefit the most advantaged. And taking other effects into account, they often actually devoted less attention to broad majority issues than to issues affecting a narrow advantage subgroup of their constituents. So what does this mean sort of more specifically? Well, if we return to the case of women's organizations, this means that while about 85% of feminist groups were active on the majority issue, violence against women, and slightly fewer, about 77%, on affirmative action in higher education, a significant but far smaller proportion, only 65%, were active when it came to welfare reform, which again was the issue I included as a disadvantaged subgroup issue. And it's important to then look at this next slide to show that this isn't because organizations focused on identity or social issues like race and gender are giving short shrift to issues of economic justice, because what we can see here is that anti-poverty and economic justice groups also devoted almost no attention or resources to issues associated with public funding for reproductive health services, basically ignoring an issue with major implications for low-income women, an issue that cuts across both gender and class, and basically falling through the cracks of the two types of organizations that are best positioned to address it, or that claim to address issues, that these intersecting issues, economic justice and reproductive rights, creating this advocacy vacuum, or what I call this advocacy vacuum. So these are data from the broad survey. I also did interviews to sort of try to get a little bit below the surface. And what I found is that talking to officers at advocacy groups suggests that what's going on, at least with this issue, and I think more generally, is that the framing of reproductive justice as a social issue exacerbates this vacuum, because it's explicitly rejecting the ways in which both public funding for abortion, and reproductive health can't be separated from economic concerns, both for individual women who need to control their reproduction for personal, financial, or professional reasons, but also as a broader political economic question about the dedication of state resources to women. And rather than drawing these connections, the people I spoke to more typically buttressed the boundaries between them and resisted the idea that they thought, the idea that an issue they thought of as affecting only women could also be an issue of economic justice. So just as one example, when I asked the executive director of an economic justice organization about his organization's efforts on this issue, he answered that there had been none. And he said, we don't work on public funding for reproductive health services. We don't work on other people's stuff, as he characterized it. Our focus, he says, has been on economic questions, and contextualizing this within arguments about strategies to shift the focus of the left away from issues like abortion and affirmative action and LGBT rights. He explained that in his opinion, the only way to defend these things that he characterized as cultural liberalism is with what he characterized as a strong populist economics that persuades white men to vote their pocketbook. In other words, the gendered implications of reproductive rights were taken as evidence that it's a social or an identity issue, and it prevented economic justice advocates from recognizing the ways in which this issue is inseparable from economics for the low-income women who arguably constitute an important portion of their constituencies. So they treat it like it belongs to someone else. And so this is related to the second thing that becomes clear by bringing the survey results into conversation with the evidence from the interviews, which is that the short shrift given to issues affecting intersectionally marginalized groups happens not because advocates and social movement organizations don't care about them necessarily, but rather because they don't regard the intersectionally constituted inequalities and issues that affect their constituents, these constituents, as central to their agendas. So one example here is that when I asked about a respondent from a large civil rights organization about his group's activity on welfare reform, for example, he said, we oppose the Clinton welfare reform plans, probably not as vigorously as we should have. We're doing so much else. There's something else shouting for attention. Even though it's important, and he sort of gestured away over there. We can't take it on, or the details are complicated and we're not quite sure. So it's not a matter of indifference as it is busyness and other things on our plate. and no room for this important issue. And this kind of thinking is related to a third major process through which advocacy groups pay inadequate attention to disadvantaged subgroup issues, which is the tendency to downplay the impact of these kinds of issues and to frame them as narrow, special interests that are particularistic in their effects, and by the same token, to construct issues affecting advantaged subgroups as what they think of as common interests that have a broad impact. So for example, when I asked the political director at a feminist organization why her group was much more active on affirmative action in higher education than on welfare, she told me, "I think affirmative action in higher education is a priority because it's one of the reasons that women and minorities have made so much progress. It has a huge impact and it affects all women who are in the workforce, or go to college, or start their own business, and are competing for government contracts. That's a lot of women." So she's taking a question about affirmative action in higher education and universalizing it, right? When it comes to public assistance and welfare reform, she says women on public assistance don't go to college, but that's a smaller and smaller set of people. We work in coalition with organizations that do work on welfare reform, but it's really just not our cup of tea. We really see welfare reform, we definitely see welfare reform as a gendered issue. It's definitely something we're concerned with and have been involved in, but just not on the same level. And I think her candor about welfare not being her organization's cup of tea is probably unintentionally honest, alluding as it did to images of respectable womanhood that marginalize and exclude intersectionally disadvantaged women. And combined with similar disparities in the kinds of tactics that organizations use and the coalitions with which they engage, these kinds of framings and constructions mean not only that organizations are far more willing to expend resources on political capital on behalf of advantaged subgroups than they are on behalf of disadvantaged ones, it also means that they're constructing their constituencies as ones that exclude intersectionally marginalized members. So in the case of women's organizations, or this women's organization in particular, women are constructed as people who do go to college, but not as people who receive public assistance. Because I'm getting close to time, I'm going to speak super briefly about the data from the second survey of advocacy organizations. Basically what this figure shows is that the kinds of disparities that I've been describing were exacerbated by constraints associated with the war on terror. So what we see in this figure is predicted probabilities showing that advocates were significantly more likely to report that issues affecting intersectionally disadvantaged subgroups became more difficult to pursue after 2001 compared to both majority issues and issues affecting advantaged members. But I do want to end on a better note. It's not all doom and gloom. I also found important exceptions to these more general trends. I found many organizations that did want to and did speak extensively and effectively on behalf of intersectionally disadvantaged subgroups of their constituencies. So I want to say a few words about what my research suggests about what those organizations do that helps them address issues in a more intersectionally sensitive or intersectionally responsible or responsive way. So just a few of those are that I found part of what separates these organizations that best represent intersectionally disadvantaged subgroups from those that don't is their commitment to a framework of what I think of as representational redistribution that I call affirmative advocacy. And among the practices they adopt to accomplish this redistribution are doing things like creating decision rules that elevate issues affecting disadvantaged subgroups on their organization's agendas. So one way of thinking about this is that they ask Mari Matsuda's other questions when considering what to work on. They're intentional about baking intersectionality into their mission, their mandate. They make it a metric by which they evaluate their efficacy and success, et cetera. They also use internal processes and practices to improve the status of intersectionally disadvantaged groups within their organizations. So a version of what scholars like Winnie Bryant's call prefigurative politics, in which they enact for themselves the world they hope to create. They also often have strong ties to state and local advocacy groups, promoting descriptive representation by making sure that their own staff and boards include a critical mass of members of representing intersectionally marginalized subgroups of their constituencies. Not a panacea, but it is a start. They try to cultivate among advantaged subgroups of their constituencies the understanding that their interests are actually inextricably linked to the well-being of intersectionally disadvantaged constituents. So what I call, drawing on Michael Dawson's work, intersectionally linked fate. They try to make effective use of coalitions by not only working with other organizations and movements, but also listening to organizations that have fewer resources and less access to power, and sharing their own power and resources rather than wielding it to get what they want from less powerful allies. They also try to balance strategic concerns and self-interest with ideological and solidaristic commitments by maintaining a long-term view, a proactive agenda, and what I think of as a utopian vision, one that recognizes that even things like women's suffrage seemed like quixotic fights at some point, and that the sort of utopian vision that they one day be fulfilled is an important one. And they also approach politics, I think, with a combination of humility, patience, and also accountability. They recognize that nobody starts out as a perfect intersectional political actor. Everybody has blind spots. Every organization can evolve. And it's the possibility of this evolution that I'm pursuing in this current work, with which I'll end. So whereas the term intersectionality was met with a lot of blank stares among both scholars and advocates when I started trying to study it in the late 1990s, early 2000s. I think we probably all agree that the last decade has witnessed its incorporation as a concept and practice into economic and social justice movements, particularly among feminists, but also among racial justice and LGBT activists. An increasing array you can see here of organizations which claim to take, and in many cases were founded based on commitments to explicitly intersectional approaches. You can sort of see them here. One of them is, of course, the African American Policy Forum, co-founded by Kimberly Crenshaw herself. And there's also an increasing criticism of and resistance to those who don't take intersectional approaches, and all of these seem like reasons to be hopeful. At the same time, as we've seen in contexts ranging from the debates within the Women's March, the Democratic Party's presidential primaries, all of the issues that people have been talking about thus far today, it's also far from clear whether this seeming mainstreaming of intersectionality has led to real changes in the agendas of national advocacy organizations, much less in broader policy debates. So I'm working with some excellent co-authors to explore what this intersectional turn looks like in practice, trying to bring together data from what will be another survey of organizations with analyses of some textual sources to try to get a handle on whether, to what extent, to what effect, social and economic justice movements and organizations have in fact intersectionalized, whether we can identify barriers to, but also opportunities for intersectionally responsible and responsive advocacy and activism, et cetera. We're also trying to get a sense about the extent to which advocacy organization officers are familiar with intersectionality as a framework, and whether these things vary by state and local levels. So I will stop there. I think I'm a little bit over, but thank you very much. I'm looking forward to hearing the other papers and to talking with you all.
Thank you, Professor Strolovitch. Well, let's go ahead and welcome Professor Ross, who will start his presentation.
Okay, great. 1 second, let me just pull up my slideshow and share my screen with all of you. Okay. Okay, assuming that's visible to everyone. So I want to thank you, Suzette, Ming, and the University of Colorado Law School and the Byron White Center for the invitation and opportunity to participate in this Rothgerber conference on the centennial anniversary of the 19th Amendment, ratification of the 19th Amendment. As an alum of the University of Colorado, I always cherish opportunities to return to Boulder, and was really excited about this particular opportunity. But I know that when we get through this, and we will, my time will come again to return to Boulder, and I look forward to that point when it does. So I'm not a scholar of the 19th Amendment. Instead, the scholarly focus of a project I hope to pursue with vigor next year is on its precursor, the 15th Amendment. My particular interest in the 15th Amendment has unique parallels to the 19th Amendment in the persistence of political barriers to the fulfillment of one of its objectives, political equality. Now, I'll start with what interests me about the 15th Amendment, which I will then connect to my project on this symposium on the 19th Amendment. I will then explore the factual predicates to my empirical project on the 19th Amendment and share with you a research question I seek to answer. Now, I apologize for not having more in terms of empirical results to share at this time at this conference, but alas, I think you all can imagine where the time has gone with a 4-year-old at home. So turning to the 15th Amendment, a unique historical episode during the congressional debates on the proposal for the 15th Amendment has been overlooked by most scholars. At the end of extensive debates in both congressional houses, the House and Senate passed versions of the 15th Amendment that would prohibit the discriminatory denial of both the right to vote and the right to hold office on account of race. However, inconsistencies between the two bills remained. According to the version voted favorably out of the House of Representatives, the right of citizens of the United States to vote and hold office shall not be denied or abridged by the United States on account of race, color, or previous condition of servitude. The Senate-approved version said, the right of citizens to vote and hold office shall not be denied or abridged by the United States, nor by any state on account of race, color, nativity, property, creed, or previous condition of servitude. At the time that the bills were passed, the clock was ticking on the 40th Congress. Supporters of the 15th Amendment knew that the next Congress, the 41st Congress, would be less favorable to a constitutional proposal extending political equality rights to African Americans. So with only 3 weeks left in the term, the House and Senate created a conference committee comprised of members of both houses that have the responsibility of hammering out the differences between the two proposals. As a historical note, the 15th Amendment is the first and only amendment in US history to be sent to a conference committee. In conference, the Senate members ultimately receded to the House version of the bill with one important modification. In a decision that remains unexplained because there are no written records of the conference committee deliberations, the House Senate Conference Committee removed language from the Senate version of the bill that was included in both versions of the bill, language protecting the right to hold office from discrimination on account of race, color, or previous condition of servitude. The final text of the 15th Amendment simply said, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The decision to remove the right to hold office from the final version of the amendment remains unaccounted for. One barrier to explanation is that there are no written records of the conference committee deliberations, and the members of the conference that argued about members of Congress that argued about the conference committee's change disagreed about its meaning. The best we can therefore do is infer meaning from the political theoretical understandings of the relationship of the right to vote and hold office at the time of the amendment's proposal. If under the political theory of the time, the right to vote and hold office were understood to be distinct rights, then the decision to remove the hold office provision was a decision to deny the right constitutional protection. What this means is that the federal constitution would not impose any limits on state imposition of discriminatory barriers to office holding, unless, of course, the 14th Amendment was interpreted to do so. But if the right to vote were understood in the political theory of the time to be related to the right to hold office, then understanding the nature of that relationship is critical to understanding the meaning of the decision to remove the hold office provision. In my 15th Amendment project, I draw a link between the 17th century English Republican theory, American revolutionary political theory, American constitutional political theory, and 19th century American political theory, and some of the historical episodes related to the theories. And what I found thus far is that a political theory about the relationship between voting and holding office had emerged as dominant by the time of the 15th Amendment. According to that political theory, the right to hold office was understood to be a subsidiary right to the right to vote, such that the granting of the right to vote to a subset of the people necessarily meant that this subset of the people would also have the right to hold office. In research that is at a very preliminary stage, I've also found that this theory of the relationship between voting and holding office persisted through the adoption and ratification of the 19th Amendment, such that the 19th Amendment protections for the right of women to vote also encompasses, or it was meant to encompass, the protections for the right of women to hold office. Now, we heard this morning some compelling accounts of the history of the 19th Amendment, and there are several great books and articles on this history as well, so I will not seek to add to that here. Instead, I want to fast forward to the current context and drawing the relationship between my account of the 15th Amendment and the 19th Amendment's protection of the right to non-discriminatory office holding, and the thus far incomplete realization of the 19th Amendment's goals. Now, when looking to one important measure of formal political equality, voting, the centennial anniversary of the 19th Amendment should be one of celebration. In the last 10 presidential elections, eligible women voters have turned out more than eligible male voters, male voters, with a 4% gender gap favorable to women since the 2008 election. But when looking to another important measure of formal political equality, office holding, the centennial anniversary of the 19th Amendment is one of disappointment. After the 2018 midterm elections, the percentage of women in the lower house of Congress, the House of Representatives, stood at 23.5%, which puts the US at 75th among all countries with lower legislative houses. While that statistic is depressing, it was much worse prior to the 2018 midterm election, which has been labeled the year of the woman, which is appropriately labeled the second year of the woman. And this second year of the woman increased the percentage of women in the House by over 3%, nearly 4%, the largest percentage gain since the first year of the woman in 1992. Now, if you're hoping that the US Senate or state legislatures would be better off in terms of the share of women in office, I have minimally favorable news for you. A slightly higher 25% of senators and 29.1% of state legislators are women, but those numbers fall far short of the 50.8% number of women in the US population. Now, what about executive office? Well, we know that there has never been a female president of the United States, and it is highly unlikely that there will be one after the November election, given the fate of these presidential candidates. The promise of women was once again eclipsed by the votes for men. At the state executive office level, 9 of the 50 governors are women, which is 18% of those not into the math thing. But there may be a valuable pipeline to governorships emerging, with women comprising 30% of lieutenant governors, the highest percentage of women in any of the 16 state executive categories. If we continue along the rate of growth of female office holding, I think we will reach proportionality someday. Perhaps not this century, but there is always the next to look forward to. And perhaps at the bicentennial anniversary of the 19th Amendment, we will be able to celebrate the achievement of this measure of formal political equality. Personally, I'm not patient enough to see whether I will have a second life to see such proportionality achieved. And I do not think that we as a society should accept such a slow road to formal political equality. And although I never met any of the advocates of the 19th Amendment myself, I can only imagine that this would not be acceptable to them either. In this project, I'm hoping to add to the literature seeking to explain the failure to achieve proportionate or near proportionate female office holding, and to puzzle through what might be the necessary conditions for achieving such proportionality in the nearer future. And I seek this not for the reason that I think that women will necessarily govern differently, although there is empirical evidence suggesting that women in office prioritize things differently than men. Instead, I think inclusive opportunities for office holding generally are crucial to our democracy for members of all subordinated classes, because it expands the pool of talented, virtuous, other regarding individuals from whom we can draw from to serve the people through their acts of governance. When we artificially limit the pool through barriers to entry in terms of office holding, we diminish the strength of our governing class and our capacity to overcome the enormous challenges we face as a nation, a democracy, and a component in our global society. Furthermore, in the same vein as the anti-federalists during the constitutional ratification period drew a direct link between voting and office holding, such inclusion enhances the legitimacy of our democratic system of government in the eyes of those who are governed. Such legitimacy is important as we will need the people to devote their energies and make the necessary sacrifices to overcome the enormous challenges we face as a nation, a democracy, and a component in our global society. So what are the barriers to office holding, female office holding? A Pew Research poll conducted in November 2014 surveyed Americans on the obstacles to female leadership in business and politics. Focusing on the polling results for politics, the survey respondents identified attitudinal, structural, and personal obstacles to female office holding. In terms of societal attitudes as barriers to office holding, 62% of respondents found as a major or minor reason for the lack of female office holders the higher standards that women are subject to when running for office. 66% found as a major or minor reason Americans' lack of readiness to elect women to higher office, and 25% cited as a major or minor reason Americans' perception that women are not tough enough for politics. In terms of structural barriers to women female office holding, 58% cited as a major or minor reason the lack of support from party leaders, and 51% pointed to women's lack of experience required to run for office. Finally, in terms of personal barriers to female office holding, which do also intersect with societal structural barriers based on assumptions about childcare responsibilities, 49% cited as a major or minor reason the fact that family responsibilities do not leave women time for politics. Now, my focus is less on interrogating these barriers, and I'm not particularly sanguine about our ability to overcome most of these barriers in the short term. Societal attitudes can and do change, but it's typically a slow process of change. Structural barriers might be easier to overcome, but to the extent that they are related to societal attitudes, it may take time to change them as well. And the personal barriers premised on the division of labor in the home has been slow to change, even with a striking increase in the number of women in the workforce over the past half century. And yet, despite the ongoing persistence of barriers to female office holding, we saw a remarkable jump in the number of women winning legislative office during the 2018 midterm election. The story of female office holding has been one of gradual incremental improvement since the 92nd Congress elected in November 1970 to the 103rd Congress elected in November 1992. Then in the 1992 election, there is the first year of the woman, in which the number of women elected to Congress increased over 4% from 5.8% to 10%, and from 31 female Congress members to 54 female Congress members. We then returned to a period of gradual and incremental improvement such that by the 115th Congress elected in November 2016, women comprised just over 20% of Congress members, an increase of 55 female Congress members over the 24-year period. Then in the November 2018 midterm election, the number of female Congress members jumped again by 22 in one election, the largest numerical increase in the history of Congress, representing a 4% increase in the number of women in Congress. Now, what happened and how did these women overcome the barriers to female office holding and win office at such a high rate? Perhaps there was a change in societal attitudes towards female office holders. One would not expect to see such a dramatic change in societal attitudes over such a short period, but there is some evidence of an anti-Trump effect that may have benefited female candidates in 2018. This chart, based on evidence from the Cooperative Congressional Election Study and a survey by Brian Schaffner, shows that in 2016, a person's degree of sexism, as captured by the survey, did not influence the probability of voting Republican. Both least sexist and most sexist voters were willing to vote Republican at about the same rate in the 2016 House election. But in 2018, after 2 years of news coverage of President Trump's treatment of women and Republican Congress members' defense of Trump, you see a change in voting behavior by less sexist voters in the 2018 midterm election. The less sexist a person is, the less he or she was inclined to vote Republican in the 2018 midterm election, which probably benefited female candidates since most of the female non-incumbents that ran in 2018 were Democratic challengers against Republican incumbents. One might also think that the second year of the woman arose from a Hillary Clinton effect. Clinton coming so close to becoming the first female president in American history might have inspired women voters in the 2018 election to rally in support of female candidates. But there does not seem to be much evidence of such a Clinton effect on voters, as surveys suggest that women voters did not take gender heavily into account in their voting decisions in 2018. According to a Kaiser Family Foundation survey released during the month prior to the November election, 75% of the women surveyed said that a candidate's gender was not a factor at all in their vote choice, and another 19% said it was only a minor factor, leaving only 6% who said that gender was a major factor in their vote choice. But what about another Clinton-Trump effect of inspiring women to run for office? Here there is evidence in support of such an effect. The number of female candidates who filed for the U.S. House of Representatives for House elections increased by a whopping 74% between the 2016 and 2018 election. As a point of comparison, the number of male candidates increased by less than 20%. But there's a big difference between filing to run for office and being a viable candidate for office. And here's where an obstacle might arise as not included in the survey of barriers to female office holding. As you can see from this chart, most of the women running for Congress in 2018 were Democrats. And although the midterm elections typically favor the party that does not hold the presidency, the 2018 midterm election was unique because of the degree of Republican-favored gerrymandering after the 2010 census that remained in place in 2015. The effect of such gerrymandering is that by 2016, the bias in the congressional map, as measured by the difference between the Republican presidential margin at the national level and the median congressional district or state, was the highest that it had ever been. For Democrats, this posed a daunting challenge to their efforts to win back the House in 2018 in what otherwise should have been a favorable year for Democrats. And yet Democrats did win back the House, and they did on the back of female candidates. According to data collected in a report by the Center for American Women in Politics at Rutgers University, of the 39 House seats that flipped from Republican to Democrat in the 2018 midterm election, women won 21 of those seats, or 54% of the total number of Democratic flips. And it was women of color candidates that led the charge, with 13 of the 21 victorious Democratic female non-incumbent candidates being women of color. The 13 women of color included 5 African Americans, 5 Latinas, 2 Native Americans, the first Middle Eastern North African woman to serve in Congress, and the first 2 Muslim women ever elected to Congress. And some of these women of color won in places where women of color are not supposed to win, as 4 of the women of color were selected or elected in majority white congressional districts. How did they do it? And how can we take from these elections, what can we take from these elections to make more leaps in the coming elections rather than returning to the gradual incrementalism that followed the first year of the woman? Are the features of the candidates or the elections that can further be facilitated through legal change? Now let's start with a couple tidbits about this midterm election that distinguishes it from prior midterm elections. One is the turnout rate. The 2018 midterm election saw the highest turnout rate in any midterm election over the past 100 years. And scoping in a little further on the jump in turnout, you can see how different the turnout was in the 2014 election, which was a big year for Republicans, from the 2018 election, which was a big year for Democrats. We know that higher turnout rates tend to benefit Democratic candidates, but might the reason why it benefits Democratic candidates also be a reason why it might benefit female candidates? Might those infrequent voters, which include young, minority, and low-income voters, be more open to voting for female candidates and less inclined to view politics through the traditional gendered lens? If that is the case, then it provides further support for the liberalization of voting laws and legal incentives for campaigns to engage infrequent voters through their canvassing efforts. Both might lead to consistently higher turnout among voters more open to supporting female candidates. A second tidbit that on its face seems like it would diminish the viability of female candidates may have in fact benefited female candidates. And that is a dramatic increase in the amount of money spent in the 2018 midterm election. The first column is the total amount of money spent in both presidential and congressional elections. The second column includes the total amount of money spent in congressional elections. And the third column includes the total amount of money spent in presidential elections. Now, what we see from 2016 to 2018 is an unprecedented 38% increase in the amount of money spent in congressional elections. And from 2014 to the 2018 midterm, we see an unprecedented 50% increase in the money spent in congressional elections. Now, that is truly remarkable. Now, you might think that this will put female candidates at a disadvantage because women tend to have less access to money networks than men, because women tend to be underrepresented among the highest income earners and the wealthy. But while this may put women at a disadvantage in fundraising, that may lead people to think that less money in politics would be beneficial to female candidates, we shouldn't forget how less money in politics might also serve as a barrier to female office holding. For parity to be achieved in Congress, female candidates will need to challenge and defeat male incumbents. Incumbents tend to have advantages in the traditional forms of campaign fundraising that rely on constituent contributions and political action committees. And the primary source of advantage for incumbents in particular is political action committee contributions. Political action committees are comprised of members of business, industry, and labor who seek to carry favor with elected officials in office by contributing to their campaigns to run for office in the next election. To the extent that finance revenue is limited to these traditional sources of money, challengers have had a difficult time unseating incumbents. And this is reflected in the extraordinarily low congressional turnout rates in the 2000s, when incumbent candidates usually had fundraising advantages from campaign contributions and PAC money. Now, on those few occasions when challengers outraised the incumbents in constituent contributions, the incumbents would easily overcome these deficits by tapping into PAC money that challengers typically were not able to raise. Now, two things have changed the campaign finance playing field over the last decade. The first is the nationalization of campaign fundraising for at least some House elections. And the second is the Supreme Court's decision in Citizens United v. Federal Election Commission, which liberalized independent expenditures from regulation. What we see in 2018 is something that we have not seen before, an extraordinarily high number of viable challengers in terms of money raised. Apologies for the blurriness of the image, but what is important is that large red bar on the left, which represents the number of Democratic challengers in Republican-held districts who raised at least $50,000.
Professor, we are about at time. If you could start to wrap up a little bit. Thank you.
Sure, absolutely. Many of these challengers raised multiple more of that turnout amount. And there's no comparable number of challengers raising that amount in any election since the enactment of the Bipartisan Campaign Reform Act of 2002. Just to show you one final chart to show perhaps the importance of money in terms of women success, female success in the 2018 election. The 2018 election marked the first election in which you see successful challengers outraise losing incumbents. In prior elections where successful challengers did not need to outraise losing incumbents, the challengers were less likely to beat women. And so it suggests here, and this is merely suggestive, that fund money and the increased access to money may have benefited female candidates in this election. And so just to close, my study will be focusing on this question more empirically to see the effects of the changes in the campaign finance environment on the ability of female candidates to win elections. Thank you very much.
Thank you, Professor Ross. I apologize if you're having problems hearing me. I think my internet may be a little bit struggling. Professor Ellis, I believe it's your turn as well. Thank you so much for the presentation.
Let me make sure that I'm unmuted. Great. So, hello, everyone. My name is Atiba, Ellis, and my talk today is called The Voting Rights Paradox: Ideology and the Incompleteness of American Democratic Practice. Let me start by thanking Professor Malveaux and Melissa and all of the staff at Colorado Law for supporting us, even though we have moved into this extraordinary time, which means that we have to gather virtually rather than face-to-face. And let me also start by giving my best wishes to everyone who, in your own personal ways and with your families and friends and your communities, are facing an extraordinary challenge. I am a scholar of the right to vote, and my focus tends to be about voter suppression. And like our other panelists, my perspective is informed by critical race theory, by legal history, and similar thinking through and thinking outside the box about things. And we are certainly in an outside of the box time. Interestingly enough, and I point this up briefly because it might be worth some conversation, when it comes to voting in particular, I live in Wisconsin, and Wisconsin is going to hold an election on Tuesday, despite the pandemic and despite repeated calls to push the election back. That is interesting in and of itself, and it reveals a broader thing about the right to vote and formal political enfranchisement, which is that the problems of the people on the margins, which have existed, are getting amplified in this time. And I think would be interesting to explore this in brief, and maybe at some point it would be worth a whole other conference, but also worth talking about in this context. But it links me to my larger contribution to this conversation in terms of celebrating the centennial of the 19th Amendment and thinking about that core goal that the 19th Amendment reflected, which is the expansion of the franchise and removing barriers to political participation. So I want to talk about that, but I want to also pick up a thread that has been discussed in the keynote from Professor Siegel and in the first panel in our historians in terms of the barriers to the franchise that existed and coexisted with the challenges regarding race and the franchise. And Professor Ross, in his last talk, it was a great teaser to me in terms of his interest in the 15th Amendment. And I certainly want to touch on that and talk about race and gender and class and the sort of intersectional problems around the franchise that lie in the background of our celebration. And so I want to bring those concerns, which have been hinted at throughout this conference, to the forefront. So certainly the notion of talking about exclusion lies in tension with what we often celebrate concerning the franchise in terms of the movement towards universal suffrage. If we look at the trajectory of how we think about the right to vote in the United States, we often think about this forward motion notion to universal suffrage and the right to vote that would be available to all. But the thought that I want to dwell on for the next few minutes is that in this particular moment of constitutional celebration, where we are celebrating the centenary of the 19th Amendment, and as Professor Ross brought to mind, we are celebrating the sesquicentennial of the 15th Amendment, that this notion of a broadly available right to vote and the notion that things that defeat such a rightly and properly available right to vote in a democracy and the heightened scrutiny that comes therefrom lie in tension with the fact that this universalism has often been opposed time and time and time again. And I want to talk about that ongoing battle concerning voter suppression and the lessons that we can learn from thinking through both the history and the present day regarding the franchise. Because I think it is revealing of a deep problem in American democracy, which is the problem, the enduring challenges of race, and maybe even more specifically, the challenges of anti-Blackness, right? But think for a second that this notion of universalism oftentimes can be, in essence, an accomplice to this problem of racial and class-based discrimination, and as we have been hearing throughout the day, gender discrimination as well. In fact, Professor Siegel in her lecture this morning pointed to a vision of universalism articulated by the suffragists based on colorblindness. But for someone like me, who is rooted in critical race theory, colorblindness can often be transformed and shaped by notions of white supremacy. And thus, even though there may be neutrally appearing principles, those principles might translate into practices that subordinate the opportunity to vote based on where one lies in terms of their intersection of race and gender and class and citizenship, even, as my following panelists will allude to, I'm sure. And in this sense, this notion of universality is in tension with the ideologies that we bring to defining universal notions. Indeed, like colorblindness in its first sort of major legal incantation in Plessy's famous, in Plessy v. Ferguson and Harlan's famous dissent there, the notion that the law is colorblind and the call for equality is tied to text that rallies the triumph of white supremacy. In that one paragraph, we see both of these things. And in this dual nature of challenging our barriers and this call to universality ought to be complicated by this realization that our notions of forward progress often trip over the ideologies that help us define who is and who is not worthy of the franchise. And that those tensions play out despite the neutral framing that might exist concerning the right to vote. So thus, even though the basic premise in the modern parlance is built around notions of election integrity, and that we have to have rules that maintain the integrity of our process, and when it comes to voting, those ideological blinders and preference creators often drive the law to tactics that marginalize people and create a political underclass. And because of that, we face things like voter identification laws, voter purges, and felon disenfranchisement, which I'll speak to towards the end of my talk. Those things seem to create this problem, a problem that I've called a dignity problem in American election integrity, which is a paper I recently published with the Howard Law Journal. But this tension is what I want to speak to as a problem of intersectionality and how there can be interest divergence, to turn Derek Bell's interest convergence upside down a bit, where in all of these moments of democratic progress, we can often see that progress being recalibrated, to borrow scholar Stuart Chen's phrase, in order to affect subordination. So, given that, I want to take the rest of my time to talk briefly about important highlights of this history, because our time won't allow us the in-depth treatment that this notion would deserve. But I want to speak to the 19th Amendment and the 15th Amendment and the struggles within Jim Crow and the modern day in order to illustrate this point that I'm making about the paradox of progress regarding the right to vote. But the real takeaway here is that race shapes all of our progress, and it shapes our lens in important ways. And even though we might focus on that, race lies at the heart of all these intersections. And in my current work, including writing a long-form project about ideology and the franchise, I call this a problem of choosing worthiness as a frame for admitting versus discouraging people from voting rights. So a few points about the long history that I want to allude to. When it comes to thinking about the 19th Amendment and the franchise, part of the struggle that we saw even prior to the Civil War and prior to the Reconstruction Amendments was this question of advancement on the basis of race versus advancement regarding gender and the like. And historians, and I claim not to be a trained historian as we see in our prior panel, but I am borrowing from the work of historians like Ellen Carroll Du Bois to talk somewhat about the history of women's suffrage and to talk to the issue of the fact that at the root of the women's suffrage movement, and as has been laid out in depth already, there was, in the pre-Civil War period, emergence of women's suffrage as part of the anti-slavery movement. So certainly the groups saw their interest as being joint and together. But with the coming of the 15th Amendment, there was a divergence and a separation from the interests of white women, from Black women, and from Black men for whom the 15th Amendment ultimately was given the benefit. So even though the women's suffrage movement grew out of the abolition movement, during the post-Bellum advocacy, we eventually see women's suffrage movement deploying the rhetoric of anti-Blackness. Elizabeth Cady Stanton, for example, argued that women were superior to men and that separating women was a deliberate insult. But moreover, she, along with Susan B. Anthony, evoked language that sought to fix the race problem so that women's rights to vote would be guaranteed at the expense of the rights of Blacks. And so this challenging language brings us to realize that certainly fear and racial subordination can work at the intersection of seeking a universalist solution and therefore problematize the advances that we celebrate. Certainly that is working on one level, but on another level, in thinking about the right to vote, we look to cases like Minor v. Happersett, which affirm the state's ability to be the ultimate arbitrator of who gets the right to vote and who suffers or who enjoys the benefit for the right to vote. And as a matter of American constitutional law, this is as true both in cases like Minor, which happened in the 1870s, as it was true from the founding, that the right to vote was a right given to the states to primarily administer. And honestly, up until the Voting Rights Act of 1965, the courts did not seriously contest the primacy of the state's role in administering the right to vote. Admittedly, states have right to vote provisions in their constitutions, but for our purposes, Minor represents the ability for the states to exclude women in the late 19th century, as well as to implement tools that would subvert the intention of the 15th Amendment, and thus by 1920, which is our measuring point for our conference today, affect both subordination of women and Blacks. And so the intervention created by the 19th Amendment certainly transformed that for women, but what I have come to call the vicious voter trope nonetheless was present and effective regarding African Americans, including African American women. And certainly the flip side of Minor is the fact that the notion of political participation could not run afoul of the literal terms of the Constitution. And so the subordination on the basis of race could not happen in apparent race terms, but had to happen in terms that affected other aspects of the identity of African Americans so that they would be disproportionately disenfranchised. So by 1920, we see the enfranchisement of women, but we also see the full power of Jim Crow voter suppression enforced by hyper-regulation through poll taxes, literacy tests, grandfather clauses, voter exclusion by felon disenfranchisement, and certainly the use of conspiracies amongst governing entities on the state and local level, and extrajudicial and extra-legal violence like lynching in order to create this space of anti-Blackness that I referred to at the beginning of this talk. And so this, in a sense, sets a clear irony that one of my colleagues in the earlier panel referred to in terms of the divergence of women's right to vote and African Americans' right to vote, or to put it another way, that there is an advance on the behalf of white women while African Americans suffer Jim Crow subordination. But another second vignette that I wish to point out, and given the time, I won't go into the third in terms of the modern day in great detail, but I've alluded to it at the beginning of the talk, and we in the Q&A can talk in more detail about voter identification laws, proof of citizenship laws, voter purges, and the like. But I want to end this conversation by talking about the race and class intersection that was about the advocacy of the poll tax. And to this, I'm referring to some of my early work regarding the cost of the vote, a paper I published in the Denver Law Review. Apologies for bringing up the competition, Colorado law friends. But in that paper, I argue about in part, the effects of Harper, but as in my training as a historian, I have a master's in history. I did research regarding Virginia and advocacy in the 1940s and 50s against the poll tax. And we're certainly familiar with the poll tax, which is the fee that one has to pay in order to vote. It was abolished by the 24th Amendment and the Harper v. Virginia case that I alluded to. But for this history of intersectional political advocacy, the point I wish to raise is that before the litigation in the 1960s, there was a political campaign in the 1940s and 50s to abolish the poll tax, advocacy to get people to pay the poll tax and participate in the system in order to defeat it. And certainly we see the resurgence of the theme of a cross-racial, cross-gender, cross-class political advocacy of progressives that in the 40s and early 50s sought to advocate against Virginia's poll tax. The effort, however, was headed off by the Virginia legislature of the time by saying that they would accede to the demand to abolish the poll tax in exchange for a broader capitation tax. The difference being the poll tax only related to voting, but the capitation tax that was proposed at that time and had enough support in the legislature would have been a far more substantial fee for any and all government services, a capitation tax that had to be paid and proof of its payment presented prior to obtaining any licenses, any state governmental permissions, or the like.
Professor,
faced with this choice, and I realize that I'm out of time.
Sorry to interrupt. About a minute.
Okay.
Sorry.
And sure. The moral of this story is that, once again, in a way that places a Hobson's choice for the advocates here, they decided that it would be too costly to abolish the poll tax in the name of a far more severe capitation tax, and thus punishing the poor, arguably poor Blacks in particular, even though it would influence poor whites as well in this approach. And so this points up, the point is these point up various aspects of this paradox of progress. And this paradox rooted in anti-Blackness, but certainly intersecting class, gender, and other aspects of identity, which over history seem to have targeted the groups that government has deemed unworthy. I'm happy to talk about the modern day in the Q&A. Thank you for your time.
Thank you so much, Professor. And now we're going to move to Professor Chen.
Right, good afternoon, everybody. And I want to repeat the thanks for the director of our White Center, Suzette Malvo, our event coordinator extraordinaire, Melissa Shenter, also the students of the Colorado Law Review, and my co-panelists today. I want to continue the thread that our panel has contributed to the conference of expanding this notion of franchise. As Professor Ellis eloquently alluded to, the paradox of progress, and the way that this triumphant theme of universalism and expansionism has not in fact included every marginalized group. Let me turn then to the specific case study of the citizenship of non-citizens, or more specifically, the question of who is a member of the political community and what barriers to equality immigrants and newly naturalized citizens face as outsiders to this political community. I would consider this then a case study of the broader phenomenon. So let me begin by reflecting a bit on the meaning of citizenship and the way that it connects this perhaps counterintuitive case study to the ones that we've been talking about today. The classic definitions of citizenship have always included political dimensions. For example, Aristotle's description of citizenship is largely one that's premised in political participation, going back to the ancient Greek polis. There are, however, competing definitions that are rooted in the Roman tradition and that have in many respects represented the American tradition of citizenship that are focused more on the rights of citizenship. And it's in this vein that the rights of non-citizens have been severely restricted in political terms. Now, more to the point, there are dueling forms of participation in American democracy. And as they relate to immigrants and newly naturalized citizens, many of whom are either Asian American, the fastest growing foreign-born group in the United States, or Latino American, who are the largest racial minority group of foreign-born origin. There are two different forms of democracy, and they are in tension with one another. Elections that result in direct political participation are not available at all to immigrants. Once immigrants naturalize, they are, of course, eligible. How even then, they are viewed with skepticism. The Commission for Election Integrity that Professor Ellis mentioned is one example of an effort to view those who are formally eligible for citizenship as being outside the political community. There's another form of participation that I want to focus on, which is inclusion in the decennial census. Some of you may know that this week we have, in fact, on April 1st was Census Day, and that the census, unlike the right to vote, is one that is extended to the total population. That is, it is one that extends to immigrants, regardless of their legal status. It includes undocumented immigrants, and it also includes legal permanent residents. Now, the tension between immigrants not being eligible for the vote, but nonetheless being eligible to be counted in the census for purposes of political apportionment and the distribution of public benefits reflects a deep ambivalence about how it is that immigrants should have a role in the political community. And it's my goal today to unravel the components of political participation from those of political representation and to make the case that both are necessary to have political equality in America. Now let me turn to the first of these two case studies, the barrier to political participation that is represented by formal and functional problems with voting. Now my co-panelists have laid out for me very nicely some of the background and the history that I would connect to this history of suppression for newly naturalized immigrant voters. I should pause for a moment because we have an interdisciplinary audience to admit that I've long chafed at this term immigrant voters that is used widely in the political science literature, because for the lawyers in the room, you'll note that an immigrant by definition, by legal definition, is not a citizen and therefore is not eligible to vote. So let me just say that it is a matter of shorthand that I use the term immigrant voters because it is so widely used, but I'm not today making the case that non-citizens should be eligible to vote in national elections. When I say immigrant voters, I am in fact referring to newly naturalized voters who are in fact eligible to vote. But the background and history, if you would, presentation mode, please, so we can see them a little bit clearer. Is it not in presentation mode right now?
No, ma'am.
It is on my side. Do you have a suggestion on how I can change? I can try to stop share and share again if you'd like.
That may be what we have to do.
Okay.
I'm
On my side, it
not the technological expert, but I'm sure.
yeah,
the
on my
answers
side,
are-
it actually looks like it's already shared. I'll give it one more try, but if not, I'm just keeping an outline up so it's not as critical as it was for my colleagues to be able to see in the fine details here.
All right.
Does that look any different?
No, I think that's what it's going to be for now. Thank you for trying.
That's okay. Why don't we just leave it like that?
IT have a suggestion? Do the IT folks have a suggestion for Professor Chen?
I don't think it's critical, so if it's all right, I'll just go ahead and continue. I was close to not using a PowerPoint, so one that's there is a little bit gratuitous, just to keep myself organized. So as I was saying, the first of the two case studies I wanted to focus on is voting as a barrier to political participation. And against the background of the 15th Amendment, the 19th Amendment, and the Voting Rights Act, and as Professor Ellis had referred to obliquely, the weakening of the Voting Rights Act after Shelby versus Holder, I see all of that as being of a piece with the kind of barriers that we see for the voting rights of immigrant voters. If you look at these in terms of the formal barriers, there are voter challenger laws, voter identification laws, and voter purges, all of the subjects that I know Professor Ellis hoped we would return to in the Q&A, so perhaps this will give us another reason to do so. Voter challenger laws are laws that empower private individuals to stand up and object or challenge the credentials of someone who they suspect is not in fact eligible to vote. 46 states still allow these kinds of challenges to occur. Now, why is it that someone might stand up and object to the right of another person to vote? Largely, it will be considerations such as their perceived ineligibility, which will of course cross over into issues of race. And as I mentioned, Asian Americans and Latino voters are among the largest and fastest growing foreign-born segments of the naturalized citizen population. In addition, conditions, not only the poll tax, but also literacy tests that have existed in the past, have often crossed over into language prerequisites that also affect a foreign-born voting population. The possibility of overzealous enforcement or overzealous invocation of these challenger laws against these immigrant voting groups is one that can certainly suppress their participation at the polls. As for voter identification laws, these are laws that are not required by the federal government, but nonetheless, states, 34 in particular, have decided to require some form of photo identification in order to receive the right to vote. The absence or the inability to furnish that photo identification will often lead to the casting of provisional ballots that can diminish the political power of the group. Now, implementation of these photo identification requirements has only been complicated by the 2005 Real ID Act, which 15 years later is still being implemented across the 50 states. In fact, one of the main difficulties in Real ID implementation has been the inability or the reluctance, perhaps, of some states to conform their driver's licenses to federal requirements that would not allow for the possibility that the driver's license could be extended to a non-citizen without clear demarcation that that identification cannot be used for federal purposes, such as voting or boarding an airplane or other such uses. In fact, with the COVID response, I saw that most recently one of the last states to come in compliance with the Real ID Act, New York, is actually is still in the process of coming in compliance. And so these difficulties result in an inability for individuals who might otherwise be eligible to vote to furnish a satisfactory photo ID. Arizona, in particular, had passed a state law that required proof of citizenship for registration. Now, parts of this law were actually eliminated in litigation, but nonetheless, it shows the ongoing effort to suppress the participation of individuals of foreign-born origin. The last of the formal barriers that I'll mention is that of voter purges. Now, states in Texas, Georgia, Virginia, and many others that became known in 2016 used this practice to remove ineligible voters from the polls. Now, if they were truly ineligible, this would not be a problem. But in many cases, there is the erroneous disenfranchisement of recently naturalized individuals because the old driver's license records may not include the updated fact of citizenship. I'll briefly mention the functional barriers to political participation as well. Along the lines of the Voting Rights Act, Section 203 of the Act pertains specifically to language accommodations that are required in districts that have at least 5% language minorities. Now, in these provisions that are often incompletely implemented, or in the case of California, very problematically implemented, where the Asian American population is fractured into so many different Asian languages, they disproportionately impact foreign-born voters, who, if there is any generalization that is true of immigrants, it's that they often speak another language. In addition, there are citizenship backlogs right now with the US Citizenship and Immigration Service that also serve as a functional barrier for those who are pursuing the path of naturalized citizenship. As compared to the statutory guideline of 6 months, delays currently range from 10 months to 3 years, on average 10 to 18 months. And if you just do the quick math, what that means is that in many states, if you were to register today, you would already be ineligible to vote in the 2020 presidential election. Let me move to the second case study, as I see that my time is dwindling, which is the barriers to political representation that exist through the undercounting of marginalized groups, and in particular, immigrants. And this time I do mean immigrants and not just newly naturalized citizens. As I mentioned earlier, as by way of background, the command to count the total population in the United States comes from Article 1 of the Constitution. Those counts, the enumeration, are used for both representation purposes and recognition purposes, as well as the distribution of public benefits. In 2016, the Supreme Court heard the case Evanwell versus Abbott and stood behind this principle that the census ought to be based on the total population and not only on the citizen voting age population, which is a narrower subset of the total population. Now, as a measure of gaining this information about who resides in the country, the census has off and on included a citizenship question. However, there has been no question in the formal decennial census since 1950. What we've seen most recently, though, is functional and formal attempts to resurrect this idea of a citizenship qualification for counting in the census that otherwise is inconsistent with the precedent. At the functional level, and the case that is perhaps most prominent in the public imagination, there has been an effort in the last 2 years to include the question on citizenship in the census in an effort, or at least with an awareness, that the result of that inclusion by the Census Bureau's own estimate would result in a significant undercounting of immigrant populations that tend to heavily fall into democratic jurisdictions. The case Commerce Department versus New York last fall in 2019 did end up defeating the federal government's effort to include this question on the census. However, to many, the damage was already done. The amount of confusion that resulted from the litigation over whether or not the question would be included itself chilled many immigrants from wanting to participate in the census. If you want to add to the chilling factors, if you can only imagine, the kinds of things that would cause someone to pause before opening the door to a census worker, the COVID response, the federal government's continued enforcement against immigrants, even though, again, to maintain the right to political representation through the counting on the census. A second area where there is a barrier to political representation specifically for immigrants is in the effort to shrink the eligibility of immigrants for reapportionment and political representation through a contraction of the total population standard to instead the CVAP, or the citizen voting age population. Now, this has been a pipe dream of conservatives in the federal government for many years. And in fact, one of the more dramatic episodes out of the census litigation was the revelation that GOP strategist Thomas Hofeller had in 2015 conducted a study showing that the congressional, that Republican jurisdictions would be favored by including this citizenship question. He, in his own study, though, said that without a congressional mandate for the Census Bureau to add this question, changing the method of legislative apportionment to the CVAP method instead of the total population would be functionally unworkable. This, of course, did not stop President Trump from trying to pursue that strategy in the litigation that I just described. And in fact, in an article I read just this week, President Trump, in looking at some of the impacts of the COVID response on the upcoming election, said he doesn't want everyone to vote, because if they did, that would disfavor the Republican Party. There have been analogous challenges in the states. There's litigation still moving through the courts. Alabama versus the Commerce Department, which has briefing due in, at least last I checked before the COVID response, in June of 2020. There is a challenge on the table to the total population formulation again, and the claim that Alabama's own votes are diluted by the inclusion of undocumented immigrants in the other jurisdictions. New York and 15 other states have intervened in this litigation for lack of confidence that the Census Bureau will fully defend the existing method of counting immigrants as part of that total population. Let me wrap up by returning to this core idea and how it connects to the panel and the conference today. The conference today, as you know, is about going beyond the 19th Amendment in order to expand enfranchisement. And our panel today, panel 2, is about both formal and functional political barriers to that enterprise. My contribution has been to underscore the political membership of immigrants and newly naturalized voters, many of whom are Asian American and Latino voters. And I've tried to do that by looking at both political participation in the form of voting and also political representation in the form of counting in the census. The connection between the non-citizen and the immigrant group to these other efforts resonates backward in history and also forward in time. It's a challenge that has confronted women, racial minorities, poor people, ex-felons, and today I put on the table as well, immigrant voters. Now, my prediction is that overcoming these formal barriers to political participation in order to expand equality would transform and improve upon both the process of democracy and also the substantive outcomes of democratic practice. Women participated at higher rates than men once they gained the right to vote, a trend that Professor Ross underscored in his presentation as well. They used those votes to vote for more social programs after the 19th Amendment. African Americans also vote at particularly high rates and used that vote to vote for more civil rights during Reconstruction and after Jim Crow with the enactment of the Civil Rights Act. Immigrants and newly naturalized voters presumably would do the same. They have an increasing electoral presence over time in increasingly important jurisdictions, and the emerging policy agenda seems to be one that would emphasize immigration reform, worker rights, healthcare, many of the issues on the progressive agenda. So in short and in conclusion, overcoming these political barriers and expanding the franchise to increase political equality could result in a transformation of democracy as we know it. Thank you.
Thank you so much for that, Professor. If you wouldn't mind, stop sharing your screen. Thank you so much. All right, so now we move into the Q&A portion of our panel. And at this time, I want to open it up first to our panelists. Y'all had such great presentations that were interconnected, and I wanted to see if you had any questions for each other before we move on to audience questions.
Can I sort of make a comment rather than a question?
Oh, of course, go ahead.
This was in thinking about Professor Ellis's talk and the issues at the very end about the poll tax and coalitions. You may know this, but this has kind of figured very prominently into, or less prominently than it should have, in some controversies within the history of political science, because V.O. Key, who wrote the kind of huge book on Southern politics that was sort of seen as the Bible of understanding race in the South in political science for decades, had a whole chapter on coalitions between Black and white women, or had sent someone out to do some research on coalitions between Black and white women on their opposition to the poll tax, but the findings didn't comport with his arguments about women and gender and race in the South. And so he basically left it on the cutting room floor. And in so doing kind of has been the sort of ideas about the possibilities of coalitions were completely distorted for decades of political scientists.
Thanks so much for that connection, Professor.
Oh, I'll just briefly acknowledge the point. I am not a political scientist, but I do remember from my freshman year seminar in political science, Key's point, and as I develop this work and revisit my own research, I'll keep that in mind. Thank you.
Now, Professor Ellis, actually the first audience question is for you as we move into those. The question is this: the coronavirus is likely to change how the nation votes this November. Do you foresee that those changes, whatever they may be, will have a disproportionate impact on voters of color? And if so, is there anything that we can do to kind of head those impacts off in advance?
So I think that I almost want to get behind the premise of the question in terms of responding. In other words, my initial response is we're at a junction point where there might be more expansive rights or there might be disparate harmful impacts. And we could imagine both. For example, I've been reading news stories about and seeing the advocacy via social media concerning the expansion of vote by mail, which in and of itself would be universalizing in a way that would heretofore be unheard of on a national scale. And in fact, I think that it's some of those provisions that the certain Republican operatives that Professor Chen was alluding to towards the end of her talk prompted them to complain that if these liberalization principles happen, Republicans won't get elected anymore. And I, on my own social media, at Atiba Ellis on Twitter, basically said, well, wouldn't it be nice, though, if we could just focus on the merits? And I would also say that to a Democrat, too, if they wanted to structure it. I mean, that in and of itself is the heart of the problem, that we want the structure to be determinative as opposed to the voters. But what I can imagine in terms of disparate impacts to put on our radar to advocate against is an example comes in mind here in Wisconsin. In order to vote absentee, you still have to show proof of your voter identification, right? You still must nonetheless, and I requested my absentee ballot online. I had to scan and send a copy of my driver's license with it in order to get my ballot. That kind of taking opportunities to amp up the hyper-regulation that we're voicing concern about, I think is the downside. So it's sort of turning up the gas under the fire that we're all worried about here. I think heading that off is, absent abolishing voter ID laws or proof of citizenship laws or other similar laws, I think that focusing on the universality of the situation and making arguments that these burdens impact all of us collectively and all of us differently because our ability to obtain these things is different in light of the virus. I can't go walk across the street and talk to someone for fear of getting sick or making someone sick, for example. I mean, stressing the more general notion of the crisis and that we need more generalized laws that are easier to comply with in the time might be a way to head these things off and have the ancillary effect of everyone realizing that a far more universalist approach actually helps everyone. And maybe we should just stick with that when the crisis is over.
Thanks so much, Professor. I'd like to move to the next question. This one's for Professor Ross. How do you believe Joe Biden's promise to run with a female vice president and making the assumption that he is successful in his bid will help expedite broader proportional representation?
I'm sorry, I'm just kind of getting like my internet is kind of cutting in and out. Can you hear me okay now?
I can now, yes. Do you need me to repeat the question?
No. Am I coming?
Believe we may be having some technical difficulties, Professor. We'll give it a few seconds. All right, well, we're going to move to the next question and we'll loop back to Professor Ross when we can hear him again. This one is for Professor Strolovitch. I'm going to read the question as written. As founder and a former director of a tiny feminist nonprofit focusing on appellate advocacy in the violence against women space, how do you cope with it being impossible for underfunded and under-resourced nonprofits to take on issues outside of their expertise when that particular expertise is critically important and not widespread?
Thank you for that question and for that work. So this is a version of a question I grapple with a lot, and I guess I'll say sort of 2.5 things. One is I don't mean to suggest that every organization needs to do everything. And actually I'll backtrack. The study that I did was not of small sort of state or regionally focused nonprofits, but rather larger nationally focused organizations, some of which still, were not super flush with cash or other resources, but nonetheless sort of on a bigger scale. I'm hoping in this next study to be able to look at state and local groups. So my expectations for them are a little bit more robust, I think, or bigger than some other kinds of organizations. But that said, again, I'm not saying that every single organization needs to do every single thing, but rather part of what comes through in the data that I've been collecting over these last many years, because they're now 2 and soon 3 iterations, is that at the macro level, when we look across the universe of all of these organizations that we sort of think of as the compensatory ones for the kinds of inequalities that we see in other realms of politics and the law, that the patterns are not good. And so that even if any single organization, and so it's not to indict any single organization or suggest that every single group needs to be doing everything. And I should say that, in the survey and in the interviews, some of these were some of the kind of most flush and most prominent and most powerful organizations who were making these statements and comments about not being, that this was someone else's issue and it's over there, or it's not our cup of tea and that kind of stuff. And then I had a 0.5 point and now I've lost it. So maybe I'll stop there since I think we're getting short on time.
Thanks, Professor. And as we have Professor Ross back, I'm going to go ahead and go back to him and have him answer the question. Just as a reminder, it was about Joe Biden's promise to run with a female vice president and if that will expedite proportional representation.
Yeah, that's a great question. And often at in-person conferences, I want to avoid a question by cutting out, but that wasn't the intent here. I actually think I did cut out. Hopefully I'm maintaining some sort of stability now. My wife's on Zoom right now, so we're Zooming it up in our household. In response to the question, it could. So one of the things that has been studied by political scientists right now is what is the effect of office holding in other realms on office holding generally. And so thus far, the studies have kind of come to conflicting conclusions as to, am I lost? Am I cutting out? I'm good, okay. It's come to conflicting conclusions as to whether there is, I guess what you might say, a coattail effect on office holding in higher offices. And so I don't know if we will know for sure. One of the things that's challenging with the vice presidential role is that it's not a particularly visible role. You have, even in the campaigns, we always think that the vice president might make a difference. It hasn't historically. Maybe the selection will be different. And then when you're in office, there's no sort of designated constitutional role for vice presidents. So their prominence and visibility will often turn on what the president delegates to them to do. Now, if you see a female vice presidential candidate and female vice president sort of stepping to the forefront and playing lead roles on things, then perhaps you can see that inspiration effect in terms of more voters sort of thinking that it's important to have more women in office. And you might see the effect of having more candidates, women running as candidates for office. But we'll see. I do think it's an important step in the right direction. But I think that more will be done to to try to counter these structural and societal biases that I think act as, and have been found to act as, a barrier to female office holding.
Thank you so much, Professor. Unfortunately, this is the part in the presentation where if we were all in person, we would stand up and clap for our wonderful presenters, but as we're not here in person, I think we just have to thank you, and we'll say goodbye for now. Thank you all so much.
Great, thank you so much to this
Thank
panel. We really appreciate it. You did a wonderful job. I wanted to share with the group. For your panel, I learned that we have an international audience.
Thank you.
So these are universal issues. I thought Professor Ellis will appreciate that. He knows that we actually met at a social justice conference in Australia last summer, and I grabbed him and I said, you have to do this for Rothgerber. So we're excited about the kind of reach we're getting. Thanks for a job well done. We're now going to take a 15-minute break, and we will resume our programming at 2:15 Mountain Time with panel number 3. So I'm going to ask all of our panelists for this panel to go ahead and be dismissed, so to speak, and we will go ahead and bring up the panel 3 participants and get ready. So if the audience can give us about 15 minutes to collect ourselves. Thank you very much.